and welcome to Law&Crime. I'm Jesse Weber, and thanks for joining us. I am here to bring you a live interview with two of Harvey Weinstein's attorneys, Arthur Aidala, Imran Ansari. This is coming because the ex-movie mogul's New York convictions have been overturned earlier today by a New York appellate court in a 4-3 decision. Weinstein was serving a 23-year prison sentence on 2 sex crimes he was convicted of. And in the heat of the Me Too movement in 2020, he remains in prison for his 16-year sentence from his 2022 LA conviction. An appellate court ruled that the judge presiding over his New York case was prejudiced and made improper rulings throughout the trial. We're going to talk about that. One of those rulings, including letting women testify about allegations that were not part of this case. The court also found that due to the judge's rulings, Weinstein himself was limited in his ability to take the stand. Now, we're going to talk more about this, and I want to bring on Arthur and Imran to talk about it. First of all, gentlemen, let me first say congratulations to you. This is a major win. I had the opportunity over the last several years to talk to you about the case. I was in that courtroom every day watching this trial. Arthur, I'm going to start with you. Your reaction to this, were you surprised?
Okay, so I'm not letting you get off the hook that easy, Jesse. You were there, and you know what you're doing, and you really know the ins and outs of the courthouse and legal rulings. Are you surprised by this ruling?
No, I am not. I am not. I believe, and I'll tell you this, I was in that courtroom every day, and I don't mind saying this. I was bothered by a lot of the judge's rulings, by a lot of the judge's demeanor. But talking about the legal issues, the two big points here, allowing the Molyneux witnesses in, allowing if Harvey Weinstein were to take the stand, then he would be confronted with a number of, not even crimes, just a number of prior bad acts that have, in my opinion, nothing to do with the charges in this case. I was bothered by it, and so I was not surprised that this has actually been an overturn of a conviction. But did I take the words out of your mouth, Arthur?
Which, honestly, Jesse, the reason why I asked you to do that is to give credibility to what I was about to say. In other words, like people say, oh, you're a hired gun and you're going to say whatever you need to say to for your client. And of course, you're happy about the victory today. But here you are, Jesse. You don't have skin in this game. You're just, an observer, a journalist. And you feel the exact same way that I feel. So therefore, I can't be that out of touch with reality. And look, credit must be given. Justice Rivera, who wrote the decision, I mean, she's a huge women's rights advocate. I mean, she has been, that's her whole career. And, some people may look at this and say, hey, you know what, how is she doing this to women? But to her credit, she took her oath of office, more important than her personal views. And I'll tell you, Jesse, I will quote my friend, the late Justice Antonin Scalia, saying the nights that he slept the best were the nights where he didn't like the outcome of his rulings, but he knew it was the right thing under the law. And the perfect example was the flag burning case. You'd think Justice Scalia was happy about joining the decision to allow the burning of the American flag? Of course not. But according to the law, that's what he should have done. And Judge Rivera of the Court of Appeals, who wrote this 75-page decision, obviously felt the same way. And her and the other 3 colleagues from the Court of Appeals deserve a tremendous amount of credit for having the strength for someone who has proclaimed his innocence to me from the minute I met him 5 years ago, right around now, 5 years ago, to today, obviously, when I spoke to him, when he uses the words, I'm innocent, I'm innocent, I'm innocent. When the verdict came in and he looked at me, I was sitting right next to him, and he said, Arthur, how could this happen? I'm innocent. And now he gets a chance to go into a courtroom and prove that innocence. And I'll tell you, Jesse, today was a great day for Americans. It really was. And I don't say that with bluster. It shows that someone who was turned into a poster boy for a movement, who there was so much pressure to get this guy that the judge threw the rule book out the window and decided we were going to convict him at all costs. And our justice system corrected that. And we should be proud. We should be proud of that justice system And all citizens, no matter how you feel about Harvey Weinstein, should be feel very lucky today that this ruling came down, because it protects all of us, and most importantly, it protects our system of justice.
Well, Arthur, let's be clear about it, right? So the court came back and they reversed the conviction on what are, essentially technical grounds. It's not as if we had a case where there was evidence that shows someone's innocent and exonerated.
Hold on. We're not going to, you know that we're not going to say it's technical grounds when you allow, he's charged with 3 complainants, and they allow 4 other people in.
Yes.
So there's one more non-charged witness than charged witnesses. And in terms of his ability to testify, they were going to allow in almost 40 prior bad acts going back to the Ronald Reagan administration. And, so that's not, I don't want your viewers to be like, oh, it's a little technicality.
No, it's not a little caveat. It's not that. It's a huge mistake from the trial court to allow in this evidence. I agree with you. But it is different than if, for example, if we had a murder case and the real killer comes out and says, I did it, and you can say someone's exonerated.
But as you know, Jesse, in a he said, she said case, you usually want to hear from the he said. You usually want to hear what he has to say.
Right.
Instead, the he said, she said case went from he is out of it, and now you have she said, with the charged complainants.
Right.
And then he said, she said from the Molyneux uncharged complainants. So it was 7-1.
Right. And listen, Arthur, I know you're busy. I know you have a really busy day ahead of you in light of this. I just wanted to ask you one more question.
You got the first.
I know. Thank you.
Got the first. Because of Imran Ansari.
We appreciate that. I'm going to get to Imran in a second. Before I do, you mentioned you spoke to Harvey. Anything you can tell us about how he's feeling or what he said in relation to this monumental decision by the Court of Appeals?
No breaking news, no headlines. Obviously, he's relieved, first and foremost. He's happy, and he's looking forward to coming back down to Manhattan and fighting these charges. Thank you so much for having me, Jesse.
Arthur,
really
thank you so much. Really appreciate you coming on, and I'll see you for the rest of the day because I know you have a busy one ahead of you. Appreciate it, Arthur.
Thank you.
All right, so now I'm going to move on to Imran. Imran, good to see you. So as we were talking about with Arthur, when you look at the opinion, it starts with every person accused of a crime is constitutionally presumed innocent and entitled to a fair trial and the opportunity to present a defense. We conclude that the trial court erroneously admitted testimony of uncharged alleged prior sexual acts against persons other than the complainants of the underlying crimes because that testimony served no material non-propensity purpose. Now, walk us through what you make of the 2 reasons that the court decided to overturn the conviction. Yeah. Why did that happen?
Sure, Jesse. I think the court recognized that this was a pylon on Harvey Weinstein amidst the breaking of the Me Too movement, where a judge perhaps felt compelled to allow this evidence in. It was prejudicial evidence. We knew that from the get-go. You were sitting there in court. And this was not about those Molyneux witnesses. This was not about those uncharged crimes. Harvey Weinstein was going into that courtroom to answer to specific charges regarding specific complaints, Jesse. And I think the court recognized that he was totally dissuaded, right? And this is coming from knowing what was going on behind the doors, knowing what the desires were of the defendant there. And he didn't have an opportunity to go on that stand, testify in his defense, because he knew it would be just a bloodbath with all these other ancillary uncharged crimes, Molyneux witnesses coming in. He was dissuaded, and his constitutional rights were put at jeopardy there, and the court realized.
Let's put this up if we can. This is attorney Douglas Wigdor released the statement. Now, he has represented 8 of the alleged Weinstein victims. 2 of them were the Molyneux witnesses. And this is the statement. Today's decision is a major step back in holding those accountable for acts of sexual violence. Courts routinely admit evidence of other uncharged acts where they assist juries in understanding issues concerning the intent, modus operandi, or scheme of the defendant. What's your response to that?
Yeah, so I know Doug Wigdor. We're we're actually adversaries on each of the civil cases, basically, that have been filed by Harvey Weinstein. He represents those witnesses, and Doug's a good attorney. But I think taking a step back, I think even Doug Wigdor would recognize that this amount of evidence, if he was representing Harvey Weinstein, was totally impermissible. It was prejudicial. It had no probative value, in at least outweighing that prejudice, Jesse. And I think if he was in the shoes of myself, Arthur Aidala, Donna Rotuno at the trial, Damon Sharonis, he would recognize that was a pylon in terms of evidence, prejudicial evidence. It completely would dissuade a defendant from taking the stand in their own defense. And I think he would also be fighting against that evidence coming in.
So let me tell you what the court said for everybody to know. In the decision, it says, in reaching this legal conclusion, we take no step backwards from recent advances in our understanding of how sex crimes are perpetrated and why victims sometimes respond in seemingly counterintuitive ways. But justice for sexual assault victims is not incompatible with well-established rules of evidence designed to ensure that criminal convictions result only from the illegal conduct charged. Indeed, just as rape myths may impact the trier of fact's deliberative process, propensity evidence has a bias-inducing effect on jurors and tends to undermine the truth-seeking function of trials. The reason I bring that up is because now it is a question of whether or not this case will be retried. I'm going to read you the Manhattan DA statement in a minute.
Yeah.
But assuming it gets retried, if these Molyneux witnesses are not allowed in, and if they rule that Harvey Weinstein can take the stand, but he won't be cross-examined on all of this other stuff, and I'll talk about that in a minute, do you think he would still be convicted?
No, Jesse, I think it changes the equation completely. If you look at the evidence, what was taken in court from the witnesses who were complainants in the case, and then juxtapose that with all the other evidence that came in for the Molyneux witnesses, and the dissuasion for the defendant to take the stand and explain his side of the story, I think it may be a different result at the end of the day. Listen, this is about evidence, right? This is about impermissible evidence, the scope of Molyneux, and what can come before a jury, which will be highly prejudicial. And I think the court recognizes that. And it's textbook 101 when you come to evidence, that this is the sort of evidence. You have that gut reaction when you're sitting there, you're hearing about seeing this ruling from the court, and you're saying, how could this be let in? It's too prejudicial.
Well, I don't understand. What was the difference of opinion? Why did the trial court allow all of these witnesses to testify? Why did the appeals court uphold the conviction? And why did the Court of Appeals have a different perception on it? What was the difference there?
Well, I think he had the trial court judge, and I'm just going to
Judge James Burke.
Judge Burke, right? Yeah. I'm not going to take this opportunity to criticize Judge Burke. That wouldn't be fair, but because he wouldn't have an ability to respond. But I think Judge Burke perhaps was sitting on that bench while you heard the crowds protesting outside. You were in the middle of the Me Too movement at its height. You had perhaps one of the biggest cases before him, and certain pressure perhaps to sit on that bench and make certain rulings at that time. It could have been conscious, subconscious, I don't know. I think it was a different situation at that trial, but we know now, and the Court of Appeals agrees, that those rulings regarding Molyneux, regarding some other rulings also, just weren't right. You got it up to the first department. You got it to consideration on the first round of appeal. Well, they upheld that conviction. You got it up to the Court of Appeals. They have recognized that evidence shouldn't have come in, and that the defendant's constitutional rights were not upheld. I think it's also a recognition, Jesse, that allowing that evidence, that ruling from the lower courts, could also turn to a slippery slope, right? It could mean that now you're coming into court and the playing field is just this wide in terms of prior bad acts.
I thought this part was interesting, where they say, the court, 3 complainants testified to defendants' violent actions on different occasions, years apart, and how they behaved toward him long afterwards. There were also significant differences between complainants and the Molyneux witnesses. All 3 complainants had long-term relationships with defendant, whereas the Molyneux witnesses each interacted with the defendant for brief periods. And complainant B explained that she maintained a consensual sexual relationship with defendant following the alleged criminal conduct, whereas none of the Molyneux witnesses testified about consensual sex with defendant at all. My interpretation of that is saying you can't show a pattern if there's no pattern. If they're all from different walks of life, and the idea here is saying the testimony, you're going to have these 3 women, you're going to have these multiple women testify. It doesn't relate to what he's accused of. And I thought that was a big component of it.
Right.
I do want to ask you about his ability to take the stand, because that's the second rationale. Apparently, they say, well, we know that the prosecution, if Harvey Weinstein took the stand, was allowed to was allowed to cross-examine him about him yelling at people, screaming at people. I'm going to talk that he hit a woman's clothes, that he insisted members of his staff falsify a photo for a movie poster, that he induced executives to lie on his behalf, that he made threats and committed acts of violence against people who worked for him. Terrible stuff, but nothing related to the sexual assaults charges that he was facing. Why did the court originally allow that in? And again, why did the second court uphold the conviction on that point?
Right, and Jesse, that was sort of the crux, the sort of when we looked at this ruling and said this is completely unfair, because as you said, this didn't go to propensity. It didn't go to a likeness to the charges with the complainants at hand. This was a pile-on someone who has become the poster boy for the Me Too movement, really started the Me Too movement with the allegations against him. Why did that come in on the trial court? Again, I think you would have to ask Judge Burke that, right? But essentially, I think it was the height of the Me Too movement. Again, you were in that courtroom. You saw the fervor around it. You saw the protesters out there. It was a wrong ruling. It was an unfair.
But it was upheld.
Ruling. It was on the first round of appeal. But that's why we took it further. We knew that that was not a correct decision. That's why we wanted to take it up to the Court of Appeals. They granted certiorari. They heard it, and we are happy with this decision.
And does that mean that Harvey Weinstein wanted to take the stand and he felt he couldn't? And does that mean that if all of that doesn't come in and he's not cross-examined on any of that and he gets retried, he will take the stand?
Well, Jesse, we're going to have to reevaluate the situation. We're going to have to see if the Manhattan DA's office, even though they say that they're going to.
I'm going to get to that in a second.
But trial is dynamic, right? You're there. Witnesses are coming on the stand. You're making decisions for your client after each question and answer, after each witness, after each piece of evidence coming in, when you're making that decision at the end of the day.
Did he want to? Because I have to tell you, I remember that moment in court, him walking aside into a private room. He walked right past me. I know it was a consideration about whether he was going to take the stand. I believe someone even said something to him in the audience about it. And I remember him saying, we'll see. It's the defendant's decision. Did he want to take the stand but felt he couldn't because he was going to be hit with all of these accusations and all these things?
Well, Jesse, I'm not going to disclose any attorney-client privilege.
I was testing Imran. I was testing Imran.
But I can tell you this, right? The equation would have been different if that Molyneux ruling wasn't there, if we knew that all those prior bad acts, including, the yelling at employees, all this sort of ancillary material, that he was going to be able to cross-examine on that, the equation would have been different. The conversation with the client would have been different, and perhaps the decisions would have been different.
Now I'm going to ask you the million-dollar question. Do you think the Manhattan DA's office is going to retry Harvey Weinstein? Why do I say that? Alvin Bragg, the DA, released a statement saying, "We will do everything in our power to retry this case and remain steadfast in our commitment to survivors of sexual assault. It seems to me the only way they can retry it is if these accusers want this to be retried, if they will come back and testify." Do you think he's going to be facing a retrial here in New York?
You know, listen, that statement comes out. That's the reaction from the DA's office after they saw one of their high-profile cases being reversed by the Court of Appeals, right? So that's the sort of party line. You're going to get that statement out, and you're going to say that at the outset. Do they go back to the drawing board and say, okay, A, will these witnesses come back and go through the rigors of trial again? B, are we going to invest our resources now that we're trying Donald Trump to, focusing on Harvey Weinstein, again, when he also still has a conviction in L.A., which is also up on appeal, and are we going to do this again? Are we going to have the ability to do it again without those Molyneux witnesses coming in? Do we think we're going to win? That's going to be a decision they have to make. I'm sure they're going to be making that decision over the next few weeks while we sort of regroup on our end, and we'll see. But I could tell you that our client has been, from day one, right, so strongly professing his innocence, if anything, professing the fact that he did not have a fair, just trial. I think the Court of Appeals has just spoken to that. And let's just talk about sexual assault, sexual abuse victims, etc. No one is saying that people condone sexual assault, right? We as attorneys, we're not doing that. We're not saying that, right? The Court of Appeals is not saying that. This is about a defendant's right to a fair trial, a defendant's constitutional rights, and a defendant's rights, particularly so, in the light of being really strung up in the court of opinion and whether they can come into court and get a fair trial in the court of law.
You know, despite this, people are going to still believe that he sexually assaulted these women, and it's not going to change people's perception of it. There are comparisons being made, I think, within 1 hour of this, that this isn't just like Cosby. You know, this is a guy who's accused of heinous crimes, who gets off. And I know I had a back and forth with Arthur on this, but it is a procedural error. It is a technical error. It's not about exonerating evidence like the real perpetrator comes out. But his conviction was overturned. I believe it should have been. I actually believe with the Cosby decision, the same thing. But having said that, you can see the criticisms and the comparisons people will make that this is like Cosby. What would be your reaction to that?
Right. Well, first at the outset, Jesse, it's still Harvey Weinstein, right? He is not popular in the court of public opinion. No one really out there is necessarily a fan of Harvey Weinstein. So I'm not surprised that that would be reaction by the public with this, the news here. But the question is, would have he been convicted alone on the testimony of those 3 complainants that came in? There were problems with that testimony. We felt it. We felt that it would have been a more effective trial on the defense if that Molyneux evidence wasn't coming in. So then you have to, answer the question: if the trial was narrowed, if the prejudicial evidence was not allowed in, would have he been convicted for those crimes? And I think the answer would be perhaps no, right? Because the trial would have taken a different form altogether.
You guys, your team lost one aspect of this appeal. The court says, we reject defendant's claim that the third-degree rape prosecution was untimely because as a New York resident, his brief absences from the state before the authorities were aware of the crime did not toll the limitations period. Defendant's argument finds no support in the statutory text. Therefore, the trial court properly discounted the days defendant was continuously outside the state and correctly held that the prosecution was not time barred. Defendant may be retried on this count. So that rape charge will move forward if he is retried. Walk me through that decision.
Yeah, sure. So, I mean, tolling statutes and the ability to toll for the purpose of statute of limitations is somewhat complex. We felt that his absence from New York didn't really amount to the level that would require tolling under the statute. We're still very happy with the main decision. Right. I mean, that's part of the decision, of course. But we're looking at the pylon, right? I call it the pylon because it was a pylon, in my opinion, of prejudicial evidence in Harvey Weinstein when the trial should have been much more narrower. Did the court find that? Will he be retried on that? We'll see if he's going to be retried altogether. That's a decision the DA has to make. And if that's the case, we're going to be ready to defend once again.
Let's talk about where he is right now. So Harvey Weinstein, he was in a New York prison. Where is he right now? What happens now in terms of LA and where he is and the status of the LA case? I mean, what happens to Harvey Weinstein today?
Sure. So he's still in New York. In fact, I spoke to him just yesterday about some other things, and he expressed, waiting for this decision. And he's still in a New York prison. But procedurally now, with this overturning, he's going to be likely remanded back into the custody of authorities back in California and LA. And he's appealing that decision also. Let's see how that trial now, the appeal on that trial, follows this one. Of course, they're 2 separate trials, but there's issues in that trial also.
Do you expect a decision on that?
So we're not representing him on that one. But if I remember correctly, that should be at some point this year, later this year. But we're coordinating with LA Counsel all the time, both on the criminal cases and the civil cases that are venued there, and also here in New York. So the defense continues.
Imran Ansari, thank you. You're going to be jumping into the hosting spot right now. Thank you for giving your perspective on this. And I want to thank Arthur Aidala one more time for coming on, giving an exclusive interview, the first one today, about this latest development. I'm going to be signing off. Imran's jumping in. I'm Jesse Weber. We'll be right back.